But let's take a look at the three major regulatory schemes and frameworks that we started to talk about. I'm going to take them in order of how they came into being. The first one is the German model called the NetzDG, and that was put into effect in June 2017. And basically the main provision of this one is that it provides that the providers, i.e. the big data companies, must deal with illegal content or face fines of up to 5 million euros. So this puts all of the responsibility on the big data users like Facebook, Google, etc., to essentially patrol whether the information that's put up there is valid and is legal and above board. This is somewhat sticky in German law because any kind of insult can be seen as a certain kind of illegal act with respect to certain kinds of accusations that are made. But without getting too deep into the weeds on that, that's one of the main provisions of this. And the idea, I think, here is at that time Chancellor Angela Merkel really took exception to mostly Russia's intrusion upon the German democratic electoral process. And so she saw the NetzDG and others in Germany as a way to really prevent, Russian users in particular from having an impact and meddling into the affairs of German democratically held elections. There's also another act within here that I haven't specifically referred to in any of the readings. It's called the Telemedia Act, and that provides that a publication of a user's data must be made available to an individual. So when we start talking about access to private data, there's also aspects of German law that cover that as well. But it was the first, and some might say the most, bold and ambitious plan to put an end to fake news per se, because it literally makes the broadcasters, the data companies who are running social media companies, puts them in the driver's seat to control, make sure that and monitor that the data and any information that's up there is appropriate and legal and true, essentially, because any kind of libelous statement would be something that would be up for legal challenge. But people, as you see, have had opinions on both sides of it. You read in the one article, there's a lot of administrators within the German state who are for it, mainly because it takes a lot of the action out of their hands as administrators to enforce the legality of these statements. Namely, it puts all the cost and all the responsibility on the companies. And that's, of course, why the companies don't like it, because it's very expensive for them to adhere to this NetzDG law. Other people, human rights organizations, have objected to it because they feel it kind of dampens free expression, because now everything that is put up there has to be weighed as to whether it is libelous or not. And that could really take away from any kind of potential joke or misstatement that could be said or stated online, which might be interpreted in a legal context as something along the lines of libel. So people were up against it as a result of a kind of infringement upon human rights, what we would refer to as First Amendment expression. Other people feel that it puts too much emphasis and too much burden on the company itself, and that because it's a legal guidelines and it's the state that enforces these laws, it should be the state that enforces whether something on social media is a problem or not the company. But, this is how German law has it. I forgot to mention, too, up here that the fine can be up to 5 million euros. So this is not a trivial hand slap for a company that might be involved. Now, it doesn't apply to every company. You have to be of a certain size and have to be dealing with a certain number of users in order for the law to apply to you. So it's not just a mom and pop store. As we'll see with all of these, there's certain guidelines that get you off the hook if your company isn't big enough. So those are the main objections. The one thing that I've seen that's kind of interesting is on the Wikipedia page for NetsDG. In terms of its effectiveness, it rated that according to the way it measures things, and I'm not sure of the study of how this was done, that 90% of punishable content on YouTube was probably taken down as a result of NetsDG. This, of course, is mostly due to copyright infringement. About 40% of punishable acts or statements on Facebook were taken down, but only about 1% of punishable acts on Twitter were taken down. So if you look at those numbers, you'll say it's been pretty effective at taking down video. Not so good at social media per se in terms of statements on Facebook, and almost, having no effect on the amount of impact it's had on something like Twitter. So that's NetsDG. The next one to come on board is in May of 2018. It's the GDRP, the General Data Protection Regulation, and this is probably the most sweeping piece of regulation. It affects all of the European Union, and it's really quite comprehensive in terms of what it covers, and goes to a little bit further than NetsDG did in terms of it's just looking at cutting down on fake news. It really is getting at more users' rights. And the first thing is about disclosure. The GDPR says it has to disclose any collection that's being done. So this is why you have, if you go to The Guardian, these little sign-off boxes that make you aware of the fact that they're collecting data when you land on their site. It also has to you have to divulge the purpose for the reason of the collection. So therefore later on, if they're found using it for a purpose other than that, then that can be an infringement. It has to say how long the data is going to be kept. It also has to show whether it is being shared with a third party. And of course this is largely the problem with a lot of the things that Facebook did with respect to 2016 in the election, is that it took the data it was collecting and shared it with a group like Cambridge Analytica, which was basically using it for propaganda purposes. It also allows for individuals to request the data. It also gives individuals the right to erase data under certain circumstances. Presumably that wouldn't apply to, for law enforcement purposes. You couldn't erase your data with respect to where you might have been at a certain place or certain time if indeed you are under criminal investigation. And you must employ, certain kinds of data protection principles. They must hire a data protection officer, so that's indeed more expense. And data breaches need to be reported within 72 hours. And if they aren't, all of these things can lead up to fines of up to $20 million, 20 million euros rather. So here the fines are even greater, but that's just the upper limit. Most of these fines probably are not going to be within that realm. Okay. Now that said, if you look at some of the places where GDPR has been put into effect and its effectiveness, you'll see that Facebook was sued for non-compliance with its opt-in for data collection. So you have to check a box that makes you opt in so that they can collect data. And if you fail to do that, then you're subject to a lawsuit. Now that lawsuit was a kind of spurious one because it was launched the very first day that GDPR was put into effect, and therefore Facebook really hadn't had time to be in compliance. And I don't know what the ruling was on that, but it was a kind of frivolous lawsuit. But the big ruling was against British Airways, which was fined 183 million euros for poor security when it suffered a data attack in 2018, I believe it is. And that was primarily because they infringed upon the last tenet here, which was that they didn't notify authorities within 72 hours that there had been a breach. Okay. The other thing about effectiveness, it says that even though GDPR is put in place, that a lot of times firms use what's called dark patterns, and this is a term that refers to essentially just deceptive practices for you to think that you're opting in for one thing, but maybe you're really opting in for something else. And that sometimes GDPR regulations are gotten around just because the little check boxes that you really don't pay much attention to at the bottom of pages really state something other than what you think it is going to. So one could argue that data collection is still being done in a rather nefarious manner, but they use these particular ways of getting around GDPR because they show people have opted for them to collect data still. So that's the GDPR. And then finally we have the California Consumer Privacy Act, which was passed shortly after GDPR in June of 2018. And the basic stipulations for that is a person needs to know what personal data is collected, know whether data is sold to a third party, know selling of personal data, access to personal data is required, and you're able to request to delete personal info, and then no discrimination with regard to individual persons. So say information is gathered that might have an impact on your health insurance or on a bank loan or something like that. That information can't be used so that you are discriminated against and you fall into a different class or category based on that particular service that is being done. So, there's a lot of similarities between CCPA and GDPR, but there are some differences, and the main difference is basically what's treated as data per se. You can see that the fines can run up to $7,500 for each infraction. So if you have a number of different infractions of people being able to retrieve their data, well, that could be a pretty costly venture for a company such as that. There's also, like GDPR and NetzDG, waivers for companies that are smaller than a certain amount of revenue. I think it's $25 million. Also, they have to be companies that are essentially data companies and have to have 50,000 or more people on their database. Otherwise, they're exempted. So most companies this really doesn't apply to in the United States unless they're big data companies. But that's the CCPA, all right? And it might behoove you to think about which one of those regulatory frameworks is something that makes sense to you. The one that's kind of hard to differentiate is between CCPA and the GDPR. And as I mentioned just a second ago, the main difference is what is data, okay? And with the CCPA, it's a little bit more loosely drawn in the respect that it only applies to data that the consumer or the user, the end user, provides himself or herself, and not data that has been provided or required through third parties. So this is only stuff that has been mined or salvaged by the individuals. By the individual companies. GDPR refers to all data regardless of service, and it covers all users despite whether they live in the EU or not. Okay, so those are the two main differences. I'm getting a little bit long here, so I'm going to end things right now. There's obviously a lot more that I could say about this. It's a world that continues to open up. Think about how you might want to start talking about some of these regulatory frameworks. Maybe you can find other information or other evidence about how effective they've been, about other stipulations that apply, and that's a way that you can start to analyze whether regulation is needed or not.